Thank you, Speaker. I rise to make a contribution to the debate on the Bail and Crimes Amendment Bill 2024, and in doing so add my voice to the contribution by the member for Ballina, who's already contributed to the debate on behalf of the Greens. I state at the outset that the Greens do not support this legislation. This bill seeks to introduce a temporary additional bail test for young people aged 14 to 18 who are charged with break and enter or motor theft offences while on bail for another offence of these types. It would also criminalise the promotion or dissemination of material that advertises a break and enter or a motor vehicle offence. New South Wales Labor has introduced this bill under the guise of ensuring community safety and targeting performance crime. But the Greens know that this bill, which flies in the face of years of expert evidence, will not make our communities or our young people any safer. We know that this bill will see more kids locked up behind bars. We know that it is going to primarily impact First Nations communities and children who will bear the brunt of these horrific and racist laws. I note the member for Northern Tablelands just talked there about the need for solutions that will work. His communities and our communities deserve solutions that will work, and we know that this is not the solution. The comments made in this debate have been sickening. Speaking about young people as evil, as the former Nationals leader did, is despicable. I note that members speaking in this debate and supporting this offensive legislation keep using the term young people. But let's be clear, these bail changes are about locking up kids, children, imprisoning children. In his second reading speech, the Attorney-General acknowledged that he is aware of concerns that tightening bail laws for young people risks increasing the number of young people in detention and affects the ability for New South Wales to meet its Closing the Gap targets. But rather than addressing these concerns, and just 2 days before the National Closing the Gap Day comes out, New South Wales Labor is attempting to ram through reforms that will cause unthinkable harm to First Nations communities. It may be that these laws are temporary and for 12 months, but the lasting impact on the young people captured by this 12 months of legislation will be lifelong. It will be permanent and it will go intergenerational, as we know the trauma of incarceration of First Nations people does. But rather than addressing these concerns, we know that what we have seen is that New South Wales Labor Premier, just a month over he signed the state-based Closing the Gap partnership to supposedly improve Aboriginal health, education and social outcomes, we are seeing this law brought to this chamber. The New South Wales government has loudly acknowledged that the status quo has not been good enough, and yet their actions speak far louder than their words. Absolutely, the status quo has not been good enough. The delivery of housing has not been good enough. The delivery of public housing has not been good enough. The delivery of community services has not been enough. The delivery and support for domestic violence services has not been enough. The recognition of a need for treaties for First Nations people in this state has not been enough. But we do not need more law and order to solve any of these problems. The bill purports to target performance crime on the basis that offending behaviour is filmed and shared online, sending a dangerous message to impressionable young people. But Speaker, what of the dangerous message that this bill itself sends? That New South Wales Labor is willing to ignore the experts and crack down on young people and children is blatantly introducing and perpetuating the systemic racism that exists within our so-called justice system facing First Nations people. We cannot overstate the significant harm that this reform, if passed, would cause. We are talking about kids, young kids, who need our care and compassion. They need hugs, they need love, they need us to look after them and hold them. They don't need more punishment. The Greens are far from the only ones with grave concerns about these proposed draconian reforms. Over 500 legal practitioners, community workers and academics have written to the Premier expressing their grave concerns about the detrimental impacts of this bill. And over 60 human rights and legal organisations, including the Aboriginal Legal Service, the Human Rights Law Centre and the New South Wales Council for Civil Liberties, have signed an open letter strictly opposing these changes, which will lead to worse outcomes for young people and kids in regional communities and their families. They have called such policy a devastating betrayal of our Closing the Gap targets, and it is absolutely nothing short of that. And I wait for the hypocrisy when members who support this bill in this place take a photo of themselves smiling and committing to the Close the Gap targets on Thursday. It is despicable. I also wish to acknowledge the contribution made by the member for Murray, who has outlined just some of the many, many things the New South Wales government could be doing to support young people that don't support a law and order approach, that doesn't involve locking up kids hundreds of miles, in some cases, away from their family. On an average day in New South Wales in 23-22, 53.3% of young people held in custody were First Nations children. I'll say that again to make sure the gravity of the statistic really sinks in. More than half of all the young people in custody in the year 2022-23 were Aboriginal or Torres Strait Islander children. Yesterday, Redfern Legal Centres published a report on strip searches by children by the New South Wales Police. They found that between 2017 and 2023, First Nations children, who make up 6.2% of the New South Wales population aged between 10 and 17, represented 44.57% of all children strip searched. In every jurisdiction where reforms like these have been introduced, punitive measures to tackle youth crime have failed. We only need to look so close as Queensland, where the state's own Human Rights Act was shamefully overridden, to see such bail laws that will do nothing to fix the youth crime rates introduced in that state. And yet we had, just last year, members of the New South Wales Labor Party joining with the Federal Labor Party, waving yes signs all over the place. And yet the hypocrisy that we come in here and introduce laws that will limit our ability to meet our Close the Gap targets is a disgrace. Those who are the victims of these crimes absolutely deserve real action to be taken. They are horrific and terrifying, but it is false to pretend that any actions being taken by this legislation will have any real impact other than a headline-grabbing reaction rushed through Parliament that will do nothing other than cause further harm. In comments to the National Indigenous Times last year, Queensland Human Rights Commissioner Scott McDougall stated that reports of children pleading guilty to charges to avoid facing longer periods of detention while awaiting trial was a stark illustration of how broken the current approach to youth justice is. Now New South Wales risks replicating this broken approach. We cannot allow the fundamental human rights of a child to be ignored and overstepped. This bill is in direct contravention with our obligations under the International Convention of the Rights of the Child. More policing and criminalisation will not make our communities, our young people, or First Nations people safer. And who is asking the kids why they are doing this? We talk about speaking to the community, but we have heard that the Commissioner for Children and Young People was not consulted. I wonder, and I note the Attorney General is in the chamber, how many young people from regional communities did he speak to before he brought this legislation to the House? Did anyone ask them what help do they need? What is causing them to enact these acts of stealing a car, of break and enter? What kinds of support do they need to be able to get them on the right path? And even if you don't care about asking the kids for their views, even if you don't care about international human rights protections, what about just thinking about the fact that these are children, kids, who need love and care, not punitive policing? This is the state equivalent of caning a student in a school or a parent using a belt on a child. We know that those measures are unfair, disgraceful and outdated, and yet we are seeing the use of our legislation and our justice system to impose punitive measures on kids in New South Wales. These reforms ignore decades of unequivocal expert evidence on how to reduce youth crime. We know that when bail is denied to children, they are more likely to become enmeshed in the criminal justice system and legal systems that will only result in worse outcomes in the long term. In the context of young people who are pushed into undertaking offending behaviour by systemic disadvantage and inequality, criminal justice-based solutions are wholly inappropriate. Speaker, if I could ask for a brief extension of time.
Time. All those in favour say aye. Aye. Suppose no. The ayes have it. The ayes have it.
Thank you, Speaker. And we know that these things are costing our communities in more ways than one. For every young person in detention in October last year, we were paying $985,500, close to $1 million, to keep them incarcerated. Imagine what could be done if that money was reinvested into the community justice and diversionary programs. Imagine if it was invested into housing. Imagine if it was invested into free transport for young people. Imagine if it was invested into programs that would assist our community members, into youth centres. But instead, we are seeing tough and punitive responses introduced so that the New South Wales Labor government can seek to look like they are acting. The solutions are not easy, but they are there. The experts have told the government time and time again what is needed. Diversionary programs, funding for community services and support, Aboriginal controlled and owned organisations being empowered to deal with what their community needs. The thing is that those things don't allow politicians to look tough on law and order. Those things don't allow politicians to look like they're doing something. The reality is, though, those are the solutions that will work. Imagine what could be done if we used that money and reinvested it back in the community. The Greens are not and have never been content to simply imagine this better kind of world. We are committed to working alongside civil society groups and communities to make this a reality. We acknowledge the tireless efforts of the Aboriginal Legal Service, community legal centres, First Nations elders and activists, legal experts and human rights advocates for their work towards First Nations justice and human rights, and for holding the morally bankrupt New South Wales Labor government on this issue to account. And we acknowledge that we are standing here today in this colonial institution debating a blatantly racist law that will cause unthinkable harm to First Nations people just 2 days before we're supposed to look at the Closing the Gap targets. And it is nothing short of shameful. The Greens wholeheartedly condemn and oppose this bill. We will do all that we can to stop it becoming law, and we call on the government to heed the warning of First Nation elders, community legal experts and human rights advocates on the damage this bill will cause. We need to do better by kids, by young people and by First Nations communities. But we also need to do better by those who are suffering and fearful of the crime rates in their communities. It is false to pretend that changing these bail laws is going to have an impact on the safety of our communities. We know what works. We know the solutions, and punitive measures like this will do nothing to address the challenge, but will cause significant harm. And let us take a minute to reflect on who is to blame. Who is to blame if a 14 or 15-year-old kid engages in a violent break and enter or steals a car? Who is to blame if that kid is then caught up in the justice system? I would say we are all to blame because we have not delivered the safety nets, the support, the housing, the care, the financial support, the emotional support, the educational support to that young person. Society has failed them, and as a result, they act in those ways. The idea that we would punish a kid for our failures is nothing short of an absolute disgrace, and is for that reason that the Greens will wholeheartedly and do everything we can to oppose these bail laws passing the Parliament.